Hi. Hello. What is up? Happy Thursday? What is going on? Hello. Let me see who's in here. I saw Bun Bun in here and I saw 𝗟𝗶𝗸𝗲. Hello, 𝗟𝗶𝗸𝗲. Hello, Bun Bun. How's it going? It is almost Friday. I cannot wait. I cannot wait. Hello to all the replay viewers, all the people that pop in later. We're going to be covering Courtney Clenney. If you're not familiar with the case, she is the OnlyFans model who stabbed her boyfriend, Christian Obumseli, in their Miami, Florida penthouse. She's been incarcerated for quite some time. Let me know if you can see me, if you can hear me. Let me get her. I'm looking something up. She got arrested on August of 2022. Hello, all good. Yay! Yay. Hello, my 5 teen cats. I know people sometimes don't lose interest in cases that are kind of silent for a minute, but if you haven't been following the Courtney Clenney case, there's been a lot of hearings regarding her case, and one of them was with the assistant state attorney releasing information that he shouldn't have been releasing to law enforcement, etc. And then there was the computer hacking that they hacked into Christian's laptop, and those charges were dropped against her parents, which they were arrested for. So there's been a lot going on with the case. Hello, Debbie. Good to see you, Debbie. And so this hearing is from, I think, like a week or two ago, maybe 2. My apologies if I'm wrong, but so I did a live on here, I think a couple weeks ago, and it was about the assistant state attorney who released and leaked this information, right, via email. And her defense team was asking for that information to be removed and for him to be removed as the assistant state attorney. And now they're asking for that information that was leaked to be sealed and the documents to be sealed. And I feel like it's just adding up so many mistakes from the legal system. I feel like will just help her in the future with her case. But I don't know, do you think Courtney Clenney is guilty, or do you think it was a mental health issue and an issue of domestic violence? Like I said, if you're not familiar with who Courtney Clenney is, she is the OnlyFans model. She unalived her boyfriend, claimed it was self-defense. We saw the videos. I covered it here. I will be doing a playlist tonight. I should have all my playlists set up. I know I've been saying that. Don't come for me. So I will have those set up, but I have covered her interrogation video, the crime scene, etc. So if you're not familiar with the case, that might help. But today's hearing is based on them getting documents sealed. There is no trial date as of yet, but it is a trial that I definitely want to be following. Dee, hello, Dee. Good to see you. I hope you're all well. Thank you, my 5 teen cats. Thank you for being here. So it's a short hearing. It's a short hearing, But I have been following this case since it happened. You didn't ask for my opinion, but I guess I'll give it. I think entitlement definitely was a factor. I do think she has mental health issues. If you watch the videos of them fighting, I see a lot of like toxic behavior. And so I do think there's a level of trauma that she's dealing with and mental health issues that she's dealing with. Does that make it okay that she stabbed her boyfriend, Christian? No, I'm not saying that, but I can understand that side of it as well. And so I personally think with the videos leading up to it, her beating him in the elevator, etc., I think that she should serve her time for that crime. But I also think that, like I said, the assistant state attorney making a mistake, all of these little mistakes do end up helping her in trial. So we'll see. At the end of the day, it's probably going to be a trial by jury. So it'll be other citizens making that decision. But I guess my question to you is, do you think it was a mutual domestic violence situation, or is she the culprit of it all and she should serve her time and she's violent and aggressive? Hello, Asane. First thing, don't come for me. We started off that night. I'm just going to be honest. You know what? It's been a long week. It's a new year. There's a lot been going on. I don't like to talk politics. I don't want to talk about the New Orleans situation. My heart goes out to all the victims. Maybe like a members vertical. I don't know. We'll see. But it is almost Friday. So although I have to work tomorrow, I'm willing to misbehave tonight. You know what I mean? Oh no, not me having to members this only all the time. In my opinion, I don't think she actually meant to unalive him. You think she was drunk or like a mental health episode? Bun, I'm curious. Gracie, no detention for you. You're right on time. Didi's like, yeah. Well, I did have some wine before this. Don't come for me. Hey, y'all, the hospital just called. Yay! Why does it feel like we've been waiting for that for a long time, Gracie? I hope it does work out. Where's the damn countdown? You missed it. You're late. Everyone give Cole a hard time. He always gives me a hard time for being late. You need a don't come for me emoji. Yeah. Okay. So don't come for me. But I'm working on emojis and I'm working on a playlist tonight. And then like I'm gonna plot some like members' life. Like, you know, if you know, you know. I feel like we could have a lot of fun. You know what I mean? Yay! Augie's here. Not me shouting in your ear. Okay, we'll get used to it. But hi, everyone. Thank you for being here. Welcome. Happy Thirsty Thursday. We're going to be covering Courtney Clenney. You missed my spiel. You probably already know who she is. If you don't, go watch the lives before. Make sure you like but do all the YouTube thingies, right? Like it, subscribe, etc., 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 etc. No countdown, no warning. I did give you a warning. So let me write the detention slip for Cole. Detention for 2 days, Cole. You get detention for 2 days. Hello, Emily's. Good to see you. Hey, Alex. Good to see you. Detention for Cole. I think that's the first person that gets detention here, but I probably should have got detention here a long time ago on my own channel. Yay, Gracie, gifting memberships. I'll be your 𝗏𝗏𝗃𝗏. Oh my gosh, I just saw I'll be your 𝗏𝗏𝗃𝗏 while I was modding at JSP. Whoop, whoop. Welcome. Yeah, no, definitely get a membership because like those verticals where, you know, sometimes it gets a little wild. I have to like members those only. I feel like I'm here to cover true crime. I love true crime. I want to cover true crime. That's what my channel is about. But I do feel like I like to have a little one-on-one, get a little personal. If you know what I mean? Detention can be fun. I agree, Didi. I got some ideas for detention. in sneaking away from detention, causing trouble. I've always been very good at that. I'm going to listen while I work. What's this one about? Thank you, Gringa. Thank you for being here. We are going to cover the hearing from Courtney Clenney, the OnlyFans model who stabbed her boyfriend, Christian Obumseli, in Florida in their penthouse. She is asking for documents to be sealed where the assistant state attorney leaked information. I know it's like one of those cases. It's not really out there right now because there's things happening behind the scenes. But when it goes to trial, you know, everyone and the mammy is going to be streaming it here on YouTube. And I've been covering it for some while. I'm going to make a playlist. So we're going to hear the hearing tonight. I know it's not a lot of fun, but sometimes hearings can be like tedious, but she has really good attorneys, Frank Prieto, and we can always make it fun. You know what I mean? You know what I mean? Thank you, Gracie, for gifting a membership. Hello, Mystique. How's everyone? Hello, the nostalgic Pod Blast. Good to see you. She had a pink cocaine issue. Oh, not Diddy coming up here. Yeah, that could be right. That could be right. Thank you. Great minds. All right. Okay. Enough of me yapping. Let's play the hearing. It's not very long, but I do think there's a little bit of spice in this, and I like that.
Funny. If everybody wants to announce their presences for the record.
Khalil Quinan and Kathleen Hogue for the state of
If
Florida.
not, put on your earbuds.
Frank
Okay.
Prieto, and Diane Crumpness for the
And then I
defense.
put on closed captions. So
And
don't come for me.
Then good
I'm trying.
afternoon. And then I have the motion to intervene from the Miami Herald.
Ooh, making a coffee might put some
we had
tequila in it.
before us,
Please do. I had some
the-
wine before I came here. Moment of truth.
What
Yeah.
defense had titled as the
had
unopposed
some
motion
wine,
to
so-
determine the confidentiality of the court records.
I don't know. How are
and
you
the
guys
state's
feeling?
memo of
I always try to come up
regards
here
to
and,
that
like,
motion.
to
So
help
we're
that.
here
I'll
right
be-
now for
Not
that.
fitting.
It does relate to the motion to depose Mr. Khalil Quinan. But right now, the motion for intervention is what I think that we need to address before we go forward with that motion to depose. Thank you. And so we rescheduled this so that we could hear from everybody, including the Miami Herald, about that request. I did read through everybody's, well, obviously the original motions, the Miami Herald's motion to intervene, and then the responses to the Miami Herald's motions to intervene, which I
Some
think were filed
eggs?
by both parties
Oh,
this week. So let me hear
eggs in the
from
coffee, tequila.
the state and defense, both about the initial motion without referencing anything that's
like
not
the
already on the court record about what you're asking to be confidential.
Never
I think
had
at the
that
last
combo.
setting, we almost went into some of those facts. We're not going to do that today. And then I'll hear from all of you about,
Not us making
I'll hear
this.
from
not about
from the
Courtney
Herald
Clenney.
about
We're
the
gonna have like
motion
a
to
thirsty
intervene, and then the
Thursday
state and
type of
defense
night.
about their responses to that.
Do you want me to start, Judge, since it's my?
Members
yes,
only.
I'm sorry, it is your-
That's okay.
Just kidding. Yay, Huckleberry!
So, Judge, I don't know.
Pause. Pause the judge. Huckleberry, good to see you here again. I saw you earlier. Gracie gifted you. Welcome. You get me for your membership. Just kidding. No, but really, we're gonna start membraning all the Melly verticals because they're too wild. They're too wild. So you do get access to that, but I'm planning some other things, some other true crime related stuff. Not just me, but hi, Huckleberry. Just don't come for me. Yeah, just don't come for me. Huckleberry's like, yay.
No, if you need me to, it's laid out in the pleading Florida Rule Judicial Administration 2.4.
Kill a swag, you're late.
Kind of the process
You're
on
late.
how that works as far as subsection F.
Muy
in
tarde. That
criminal
means
cases,
too late.
which takes you to a few other
But
subsections.
no detention for
but
you.
really
I take the
it is
detention back. No one's going to
C9A1.
detention.
Little I, Roman numeral I, that says that records are exempt if it prevents a serious and imminent threat of fair, impartial, and orderly administration. So that's kind of where we start.
If you just popped in here, it's Courtney Clenney. Her defense team is fighting to have documents sealed where the assistant state prosecutor a couple weeks ago leaked information. I kind of talked about it at the beginning of the live, so make sure you go watch it. But I have been following this case. I have previous lives, so make sure you go watch it, please. Please.
In the rule. And then
Hey,
when you
Patronus.
you receive the document in
Dee
question.
Yeah, don't come
And,
for me. Don't come for me.
you know,
I'm at work
I
right
think
now.
the
All
first
right,
thing to
Coach
say
Glad.
is that document
You're
was
excused.
drafted
Patronus, hello,
specifically for
Patronus.
litigation purposes. I think that's clear. I also think, I know one of the arguments
Hey,
the
Britt.
prosecutor made is
Beautiful
nothing
Britt,
within the
hello.
document has
No.
not already been
To be
publicly
announced.
stated by either
Mhm.
of both defense
Yeah,
counsel,
Dee Dee.
had not already been made public through discovery or will.
The reason why there hasn't been a trial is because her parents got charged with the computer fraud, breaking in, hacking in. Then they got released, or, you know, they got arrested and charged. Well, they didn't get charged. They got arrested. Their lawyers fought it, and they got the charges got dropped. And now the assistant prosecutor, state assistant prosecutor, whatever. He, I did a live on him before. He leaked information via email, and so now her defense team is coming back and saying that they, one, want him removed, and two, they want that information sealed. It's only helping her case at the end of the day, if you ask me, with all the mistakes.
Will not inevitably become
We're listening
public.
to the hearing
What is
from a week or
inevitable
two
to
ago.
become public is not something that should matter to the court, because the defense in a case does not need to be laid out, and until and unless the defense is ready to do that. Could be motions
the judge.
limine that the court puts
The
in
judge is like,
order as far as when
You have
that's
some wine?
due. It could be, for example, just generally speaking, if a defendant were going to testify at a trial, the court doesn't get to know that. The defense doesn't have to say anything. The prosecution doesn't get to know that.
Oh, well, I heard
unless
defense team is
the
pretty damn good.
Defense announces it, or right before it's that portion of the trial, the judge asks that of the defendant. So I think we can generally speak about the document without going into the specifics of it.
Making the most
Just
of
like
it.
anything, it's obvious any defense lawyer is going to do investigation and do
Okay.
research, legal research, and try to find
Not
witnesses.
Robert.
Those are
Same for me.
generalities, which we can talk about without getting into the actual specifics about what that is in the document. And I think that is what the rule requires for the judicial rule of administration. It says you must be able to specify and identify it, and with specificity, but without going into the reason why it's privileged. So I guess the real question
Look at the
here
judge.
is
Look at her
this
face.
document privileged? It's attorney,
Like-
client, and work product.
Fake
We believe
smiling.
it's both. And the standard is different
What are you
with
saying,
respect to
ma'am?
both. And so I think the first thing the court needs to do is, one, determine if the document, is attorney-client and or work product privilege. Two, if the court does believe it is one of either of those, whether it was waived when the defense disclosed it to a third party that was not Ms. Courtney Clenney. And three, even if the court believes it is one, not privileged,
Please
or
do.
two, yes, privileged, but was waived,
I would share.
should that
Sharing is
still
caring.
be kept confidential and sealed? And I
Sharing is
think
caring,
this is
baby.
the only part, and I'm not going to speak
We're gonna talk.
for
We can
Mr.
talk after
Ponce,
this
but
thing.
I think that's where we kind of differ, which is even if the court doesn't believe this is a privileged document or believes we waived it, it still should be kept confidential because it's information that should not be disclosed to the public. So that's kind of where we're at. And I'm happy to go into
Don't
each of
them
those.
come
I
from
did
my-
brief them, but I can speak briefly as to each of the privileges first and why we didn't waive it.
Give me
Okay.
your bullet points on the attorney-client
Oh,
privilege
Kina,
and
come
then
from
go
my
to work
bed.
product, yes.
Okay. So with respect to attorney-client, if you look at 9502C 1 and 2, specifically a communication is
He's an
confidential
angel.
if it is not intended for third parties,
He's a little
except
angel.
one, those to whom disclosure is in furtherance of the rendition of legal services.
Hair of the
and
dog. Give me
two,
one.
those reasonably necessary
I
for the
want one.
transmission of the communication. So the question here is,
Thanks,
what
Kina.
is in furtherance of the rendition of legal services? We
Sarah?
know that the Clenneys,
Sarah's
Mr.
late.
and Mrs. Clenney,
Hi,
the parents,
Sarah.
are
No
paying the
detention.
legal
It's
fees.
2025.
That came
We're not
out in
getting
the
any
Arthur
detention.
hearing. Mr. Clenney
Speaking of privilege.
testified and he talked about it. So the fact is,
Okay, yes. Alexandra says, speaking of privilege, let's speak on her pretty privilege and white privilege, which is why she didn't get arrested that night. She didn't get arrested that night. She got arrested in August of 22 while she was in Hawaii, allegedly in rehab. How do you feel about that? We know how Alex feels about that. Oh no, it's not detention. Detention for everyone. Why? Because we're gonna get picky in detention. Just kidding. Calm down. They treated her crazy ass like she was a victim. And then we saw the video in the elevator, in the hotel room with her friend recording it. If you see something, say something. Why was a friend recording that? Like, because she was an OnlyFans model? I don't know. I have my opinions about that.
And this really applies to any case where family members are paying
Because she rehab,
for the
right?
fees of their loved one. Defense attorneys do speak to them because they need to discuss. Can you imagine what the ramifications would be if I just went to a client and I said, for example, give me $50,000, and I'm just throwing a crazy number out. Give me $50,000. I'm not going to tell you what I'm going to do. I can't tell you anything about the case. I can't tell you any experts, any investigation, any motion. I'm not going to do anything. That's just not practical. And that's why the court specifically in this rule, actually, that's why it specifically allows for attorneys to be able to discuss if it's in the furtherance of rendering the legal services. And if you look to the case that we cited, 𝗟𝗲𝗃 versus Stevens, that's 𝗟𝗲HEISER versus Stevens, STEPHENS. That's a fourth
Like I said, her
district
defense team
case
is
from
pretty good.
1998. And there's really not a lot of cases on this, Judge. So really this
Look at
fourth
the
district
judge. I
case,
agree,
it
Bumba.
was
She's
a
like,
mother
huh?
who
a
communicated with the
matcha.
lawyer about
Someone
hiring or
need
retaining
my
them
matcha.
for her son. The question was whether that communication was
Don't
privileged.
you get those
And
vibes?
the court said that yes, it is privileged because it is in furtherance of
love me
rendering
a
legal
matcha, though.
services. The state cited State versus Black, where it was not considered privilege, and that was a jail phone call between a defendant whose sister
They have
made
money for a good defense.
three-way call
Exactly.
to the attorney.
Exactly.
And what the
Because
court
not
said
everyone
is,
is
no, this is not like the
entitled to
case
that.
of 𝗟𝗲𝗃. This is different because one, it says the call is going to be recorded as you're making the call, so that should have been known. And two, in that case, the attorney didn't
Didn't you know,
explain
Judge?
why, that person's needed to be on the call, so it can be distinguished.
Sounds like we're
As
asking problems here
far
at this
as,
hearing.
and just to be clear, Judge, we were communicating what needs to be done in the case because they need to understand in order to be able to be prepared for the costs that will be involved and to justify the fees that were being charged. So I think this clearly falls within a
Abuelita wrote to
communication
her.
that would be
You're crazy.
under attorney-client.
I have my glasses.
Now, with
Just like-
respect to work
Shut
product,
up.
work product is actually even.
Let me get my glasses on.
It's even broader, and the court knows about this because in the last hearing.
Let
we
me get my
had,
glasses on because
you
I can't
even
see the
in the
bullshit.
order,
Okay, now
you
we're good.
distinguished
We're good.
between opinion and fact work
Back in
product.
business.
The case of State versus 𝗟𝗿 is very good at kind of laying that out. And actually the state cited a case that it doesn't really apply. It was in the corporate context for attorney-client
It was
privilege,
denied twice.
but it gives a great analysis of work product privilege. And that is Burrow versus Forjas Torres, BURROW. Forjas is FORJAS.
I don't like this, Judge.
Torres, TAURUS. It's a
It's like
Southern
me
District
being
of
in a
Florida case from
me and Megan.
2018. I have a copy for the court if you would like.
Oh, Patronus, well, I'm glad you're here. I hope you're feeling better. And I'm
And
sending
really,
you
if you
all the
go
good
to
energy.
page 2, Judge Torres does a
Against
really
the
great
logic.
job
Hello.
at setting forth an analysis
Try sneaking in.
on work product. He
Hmm.
talks about the difference between opinion work
See you.
product and fact work product. And
Hi.
what he says on page 2 in the first paragraph dealing with the work product
He needs
doctrine,
coffee.
he says, and this is on 1227 page, because the work product privilege looks to the vitality of the adversary system rather than simply seeking to preserve confidentiality, it is not automatically waived by the disclosure to a third party. It requires the party asserting protection under the work product doctrine to demonstrate that the drafting entity anticipated litigation at the time of the documents were drafted. I mean, clearly this is the roadmap, what we're going to do to prepare for trial. So I don't think there's any question it was drafted in anticipation of litigation. And because this is about what it is, the logic behind it, the rationale of work product is that your adversary doesn't see your mental impressions. And that's what.
Can I just pause for 1 second? Like, I know this lawyer is doing a very good job. Yes, very good job. But like, we saw the video in the elevator, right? We saw all of the videos. If you didn't watch, please go back and watch. I do a deep dive on the case. We do the interrogation, and then we do the crime scene videos. I don't know. I feel some type of way about that. The Addie voice is annoying. Don't come for me, Didi. Doesn't seem like anyone is paying attention. Well, she does have a good defense team. I will say that. But I also think she's trying to get released, 1, on bond, and 2, she's an OnlyFans model, right? So she's entitled, yeah? Or no? I'm being sarcastic. But she has been incarcerated since August of 2022.
Opinion work product is. It's the mental impressions
No
of
trial
the
date
attorney.
announced as of yet.
Clearly, these are the mental impressions of myself and my team. And so the question really is, was it disclosed in a way that your adversary would reasonably get access, that I would reasonably know my adversary is going to get access to the document? And the question then would become is, okay, I sent this email to the Clenneys. Would I have known that Mr. Quinan or any of the prosecutors in the case would have been able to get access to the case? I would have to assume that and have knowledge or evidence that they got an iCloud warrant for them. I couldn't know that in the case. The parents are not part of the facts in this charge, and there would be no reason for me to know that. And let's assume that even I was afraid that
so do you guys think that it was
could look at it. This is why I titled it privilege.
What do you think?
I titled the document,
we need to talk about this.
Checklist of things to do - privileged. And I agree with Mr. Quinan, just calling something privileged does not necessarily make it so, but this clearly is a privileged document when it's my mental impressions. It's work product. I claim it as work product, and I wrote that it was privileged. So the question becomes then about waiver. And just to go back in that case, on page 4, it says opinion work product enjoys a nearly absolute immunity. It is much more stringent than attorney-client privilege, which I still believe belongs here, but it is very hard to waive opinion work product privilege. And so then we have to ask ourselves, did that happen in this case? And in the work product aspect of it, Judge, no, I couldn't have known. I did everything to protect that document from being disclosed to people other than who was on that email. And the prosecutor stating that we have disclosed some of what's on it or will inevitably be disclosed, it doesn't matter. If a document is privileged, it's privileged from when it was. And
it doesn't matter. We saw the video. That's where my thought was going.
Like, whether it's a roadmap of my case, whether I've already filed a defense witness list with some of the witnesses, whether I filed some motions, I can tell you that at least 9 points in there have not been disclosed to this court, to the media, to the prosecution, to the public. And whether the defense inevitably decides to put that out for trial, I don't even know yet because we haven't even set a trial date. We're still
Hey,
preparing,
Scott,
we're
good to
still
see you.
investigating. There's a lot that goes into
for being
it. So
here.
I don't even know at this point, but there clearly could not have been any kind of waiver. Let me just see if there's anything else. with
She beat that
respect to
man
the
and
waiver.
verbally abused him regularly. I agree, Alex. I agree.
And I don't know if you have any specific questions about what I've said so far.
We're not gonna have like a little Melly moment now, but
And I would probably wait to go into the third point, which is
okay, Pantera.
even absent
Hello.
those things, unless you want me to, but
You made
even,
it.
We can wait and see whether or not, I agree with the Herald
Right.
that it's.
because I don't think
going
we
to
get,
decide one
Okay.
or decide the other.
I don't think we get to 3.
Okay.
So, okay.
Whoa.
All right, so let me hear from you, Mr. Quinan, about those points about the privilege first, and then we'll get to
A
the
little
ceiling and the
moment.
confidentiality.
Yes, Judge.
Oops. We're
I
not
think I
going
would
there
like to
right now.
begin with
Maybe
Ms.
after this.
Puglisi's argument that even if it might have been waived in some respect, the document,
Yes,
because
Rita.
it's quote opinion work product, maintains its privileged nature, even if she went on TV and literally said the 20 items on that. And I think that's incorrect. Just as a premise, if we proceed to trial, Ms. Clenney's convicted and she attacks her representation as ineffective, that privilege is waived. We get a copy of the file, we review a copy of the file. As common within
Right.
a Rule 3 litigation, I think it's actually explicit in the rule and the doctrine about the waivers of privilege that come with that. So that's not correct. We have to read all of these rules together with one another. And so, as Ms. Puglisi correctly cited into 9502, it has to be in furtherance of the representation. So, was this email communicated to the
I agree,
parents
Alex.
first as their other clients as witnesses? Yes or no?
Alex says, I think this was off on and angry on drugs, but I also believe that is her character. That's not just drugs, that's who she is. She's an OnlyFans model. Not that that matters, but I'm just saying, you know, she was wealthy, she was successful. I believe that is who she was as well.
I think it's unequivocal now. That wasn't, this is
Do
what
I
we're doing
think
to
it could have
prepare
been
you
an
as
ass
witnesses.
sometimes?
This is what
Yeah,
we're doing on
sure.
Courtney's case.
It takes two to tango.
So it's unequivocally
but-
uninvolved to Kim and Deborah Clenney's
Yeah,
representation.
Gracie, I do it after the
by,
live, so I need to
Frank and
post
Sabrina.
it after.
Or excuse
I
me, Ms.
know.
Puglisi, Mr. Prieto.
I conceded.
My brain just went to your first name. So it's unequivocally uninvolved with that representation. So it's
Yeah,
regarding Ms. Clenney's representation. What within that email really discussed we need, so for example, I'm gonna use Ms. Puglisi's example of money. We need $50,000 to do X. Okay, was that in that email? It was not. Was it, we need you to sign an authorization of, you know, school records from Ms. Clenney so that we can build mitigation? Again, hypothetical situation. That's not what was there. That was, we want you to know what we are doing. Email. And that is a voluntary, that is a textbook voluntary disclosure to a third party, period, bar none. There was no request for work. There was no request for assistance. And the 𝗟𝗄𝗃 case that we cited to, that I appreciate Ms. Puglisi mentioning, and in the original privilege litigation, we also cited to a case called 𝗏 versus 𝗏, and I can get that cite for the court, where there are circumstances where family members can be agents. So in 𝗟𝗃, that was a juvenile who was in custody and could not retain his own counsel. So his mother went to retain counsel. And what was privileged in that discussion was the discussions with the lawyer about the son's case, period, in terms of retaining that lawyer. That's not what we have here. Again,
Or
Mr.
record, right.
Prieto and Ms. Puglisi, as we argued in that
And
proceeding,
control my anger, right?
were already retained by Ms. Clenney. They had every means of going to go see her at the jail and talk to her at the
I'm glad
jail
you're here,
and explain
Pantera.
what they need and why they need it. And
I'll be
as
in
it pertains to her
detention.
parents, if there's any kind of bill,
Stop.
for example, Ms. Clenney has frequent calls with her parents. She could say, Dad, I spoke with my lawyers and they need
Detention is good
the
because I'm always there.
$50,000 for the thing that they're doing. That's perfectly fine. That's perfectly protected. But the problem here is that that's not what existed in this email. That's not what occurred. Besides that, I don't entirely agree that it's opinion work product. At the end of the day, it's just a fact work product of, you know, we have to do X, we have to do Y, we have to do Z. It's not, I think that this is going to be a problem, or I think this witness is not credible, or what would actually impart impressions there. It's essentially call the witness, schedule the witness, get this, and I'm not quoting anything there. These are all hypotheticals because I have to tiptoe around it. It's a to-do
Whoa.
list.
Settle
It's
down,
not
guy.
we think this, we think that.
Not the
So
attitude in the
respectfully disagree
courtroom.
as to whether it's opinion work product.
Hello, Nicole. Good to see you here, my love.
As it pertained to the instant motions, again, this is a slight shift from the privilege, because again, our position on the privilege has never changed, including as it pertains to the other litigation. And of course, we respect this court's order on that case, though we disagree as we outlined in our pleadings. This is inherently different in various different respects. Again, explicitly voluntary disclosure, but beyond the voluntary disclosure is the remedy. Well, I guess I'm getting into the other argument, so let me back off of that. The state's position as it pertains to the confidentiality was that all of the matters should be confidential because it would necessarily limit our ability to discuss in the response to the deposition motion the document, because that's
sounds like I'll bring
good
the
chunk of
beverage.
their
Okay,
position.
bring me one too.
So all of the proceedings should be confidential if the state is correct and the court agrees with the state and the court grants our motion or denies the defendant's motion, however that proceeds, then whatever is appropriate to be unsealed would be unsealed. The problem is that
thank you, Didi.
candidly, the defendant in their motion to compel and our deadlines in responding to that motion to compel required us to address.
Pause this guy. I need to make a public service announcement. Didi and I have been friends since the court TV, since I was on court TV. Yeah. I haven't been over there in a while. If you know, you know. But I love you, Didi.
At least one bullet point in that respect. So it's put us in a position now where
thank you, Didi, for renewing your membership too.
So there's that aspect. And then finally, as Ms. Puglisi mentioned, there's at least 9. I haven't really re-reviewed that document on purpose for this court's reasons and for collateral matters. But if there are 9 things, and I'm assuming it was 20 items on the list, just taking their word for it, 11 of them should not be redacted. So at the end of the day, that's the bottom line law is, as I don't care whether it is or isn't sealed, but that's just the state of the law. So
with respect to Mr. Quinan doesn't believe that it's work product. So the rules, opinion work product. The rule states the mental impressions, conclusions, opinions, or legal theories of a party's attorney or other representative concerning the litigation. That does not say and in between there. It says or. The mental impressions.
Tracy, I'm sorry.
Those bullet points, it does not say it has to be in a paragraph format, how it needs to be put. Those bullet points show, after evaluation and knowledge in the case, things that need to do. Those are mental impressions moving towards litigation. I mean, I don't think it could be more clear than the fact that this is opinion work product. Now, as far as the attorney-client privilege, yes, this is not a communication that involved our representation of the Clenneys as the parents. This had to do with Courtney Clenney and her representation. And it's just not practical what the state attorney is saying, and I don't think this is what the rule says, which is that, yes, we were retained, but that doesn't mean that costs don't still come up throughout the case, that you're not still discussing with the family about the case. And it says here, he says, Mr. Quinan said, it's what you want you to know what we are doing. Yes. How is that not disclosure in furtherance of the rendition of legal services? That's exactly right. What he said, it falls exactly under that definition. And so
I'm freaking out. Are you guys freaking out? Who's freaking out? Am I the only one freaking out? Okay, Courtney Clenney's being charged for stabbing her boyfriend in a hotel room, right? She's claiming self-defense. Her parents were arrested, charges were dropped. The assistant state attorney from the live a month or two ago that I did, he was leaking information via emails. It's easy to be like on the outside and look at it and be like, she's guilty, she's abusive, she's toxic, she's a drunk. Maybe not. Maybe she has mental health issues. Maybe she's an alcoholic. Addiction is real. Mental health is real. But I feel like if assistant state attorney is making that mistake in a case where you're involved, I'm involved, your family is involved, it's a big deal, right? And so she's a high paid OnlyFans model. So I feel like it's going to help her at the end, right? And I do think she's guilty. I do think there's other factors that play into her, like her mental health, etc. But again, we see the justice system kind of fail, right? Like they're making these attorneys who are these people that claim to be lawyers, assistant state attorneys. We're questioning everyone.
It's just, defensive attorneys don't do that. They
What up,
don't
YouTube Straight?
talk to their clients about the fees when
What's up?
she has no access
How about
to the
YouTube
money.
Street?
So you're talking to the
You know
people who
how-
have access to the money and pay it.
YouTube Street's
And
just
you're
in
talking to them
trouble
about
today.
what you're doing. And this is just
We're
very,
just- we're just,
common communication.
you know
And
how
as
I get
far
on
as
here.
if,
Get to
even if
the
we
point,
disclose some,
hello.
because that's part of our case, we've done it through filing, defense witness lists. That doesn't mean that, okay, you can unseal or disclose part of it. I've not read any case that says part of the document can be privileged and part not. Now, I have read some cases that they've talked about, okay, if you have 5 documents, maybe one document would be sealed and the others are not. But there's never been something that, okay, part of this document it's a privileged document. It doesn't matter and it should not be disclosed.
Mhm. I agree.
And again, I won't go into the third point because I think it just, it would matter for the court to determine whether it's privileged or not first, and then whether we waived it. But I think the strongest argument here, I believe work product has not been, or sorry, attorney-client hasn't been waived, but either way, the standard is not the same between the two.
Get to ducking point. I'm a little surprised you don't know anything about this case. She was an OnlyFans model who was dating Christian Obumseli. She stabbed him in a hotel room, is claiming self-defense. Rugs played a factor. And then we see videos of her beating him and verbally abusing him in the elevator and then hanging out with their friend. I did 2 lives about this previously with the body cam footage and the crime scene footage. So make sure you go watch. I saw Bun gift too. Thank you, Bun. Thank you, Bun, for gifting. Not the short-term memory. I can't remember who was that. Oh, was it Gracie that gifted earlier? Oh my God, don't come for me, please. Who gifted earlier? Anyways, thank you, Bun. I got distracted by the comments. Thank you for gifting. I didn't see
Almost
who won it.
always
the gift
immune
membership.
in the opinion work product.
Let me
So
go
I
back
would
and
just
review.
make sure it's clear that the standard is different.
Texas girl, welcome.
And I don't know what Mr. Quinan needs to say that needs to be on the record.
Yay!
Can't
Gracie.
say without like
My memory's trash.
us having to
Don't-
seal the entire proceedings. I feel like
Smoke in high school.
we all know the court and the attorneys here involved
Know how that
know what it's
Hello, big
pertaining
girl.
to.
That's what we're gonna get to
Not me
next.
being
Okay.
judgmental.
Okay, so this is the issue of privilege. And what I want to hear next is what it is that, given what you're arguing is
Happy New Year,
privilege,
big girl.
what it is that you're asking, defense is asking to be sealed versus what state is asking me to be sealed. And then we'll hear from Miami Herald about their response.
So I
to
think the
that.
rule, Judge, does, if you go through the case, Lewis versus the Miami Herald, I think it does lay it out. And I think the biggest thing at the end is it says it has to be the least restrictive. Because
So for you guys, it's just essentially the one document.
it is, I think that protects it, as long as we are not discussing like the absolute details of what's included. We can talk around it in generalities, but I don't see, and I haven't heard Mr. Quinan point to anything that makes me feel like we can't do it and just seal that one document.
All right, so Mr. Quinan, before I get to the Miami Herald, why is it that you believe in, Council
Just come
Herald
here and get
also
to ducking
suggested
point.
that you discuss
Come
this
here.
with
I
them?
got you.
Why do you believe that
I got
more
you,
things
Vicky.
need to be sealed if that
Vicky?
if I decide that that document needs to be sealed?
Judge, as it is, just as a premise, in our response to the motion to compel the deposition of myself, I had to note at least a single quotation about paragraph 19. Our response, we had to, for lack of a better term, neuter it.
Neuter?
So we couldn't go in through the dynamics and the aspects. We can only touch about the topics broadly as to privilege, waiver of privilege, why the waiver of privilege was perceived and assumed under those circumstances, and so on and so forth, just kind of broadly. As the court recalls in the litigation on the computer case, the pleadings on these topics were north of 20 pages. And
The
this one
shade on the computer
obviously
case
was
that got dropped.
10, for several reasons, but we could not go into meat and potato issues. Again,
Potatoes.
as we've been tiptoeing around here, and as admitted by Ms. Puglisi, at least 11 of the 20 items have been disclosed already publicly. And again, that buoys the point that voluntary disclosure is waiver, period. So, which, by the way, it's their burden to show through evidence, which they also have not done. You know, counsel's assertion is not enough, and admission that that this was disclosed to
Don't come
party
for me, none of you.
consent,
No.
as we noted in our arguments, you know, that's essentially it.
Oh, maybe do, I
There
don't know.
was consent to tell the parents the status of the case. Because at the end of the day, as the court noted, and the state relied on both internally and externally through advice and research, the parents' representation by Mr. Prietz and Ms. Puglisi was problematic to begin with. That doesn't preclude it. We've gone down the rabbit hole. That's a dead horse that I don't want to beat any further. But the point is that this has nothing to do with the parents' representation, and it only exclusively has to do with Ms. Clenney's representation. And it's completely unnecessary to have been disclosed in those circumstances. Again, the proffered excuse was that, oh, it's to let them know that we need money or we need this. That's not what that communication says. That's just telling them, hey, this is a status.
That again goes to my determination of whether
Yeah.
it's privilege. So I'm asking you, why it is that you believe that you can't just reference the document in your pleadings or reference the bullet points in your pleadings without having to seal
The
everything?
judge.
I mean, a standard legal analysis is like in this case where X, you know, Y happened. I cannot do that. I mean, that's just a practical aspect. So I have to make these arguments broadly about there wasn't privilege and privilege was waived, and I can't address why or how. I can only really say, et cetera. And as it is, again, referencing the court to page 7 of our response on the motion to depose, we narrowed it as explicitly as possible to the pertinent bullet point as to how the document even came up in our search. So, you know, that's just the practical reality of being able to respond really neuters our ability to address it. Even if we
why
just
the
go ahead
neuter?
and say, you know what, the court relies on that and on what we've already put and is understanding our arguments around the parameters of that. Again, the first bullet point had to be disclosed. That was part of the problem with this timeline of the briefing, because the bullet point had to be referenced, absolutely could not go without being referenced on paragraph 19 of page 7 of our response. So we were okay with the records being sealed, hence why it was called an oppose.
I will be
for the purposes of just getting this over with. And then however the court rules is however the court rules, and whatever's appropriate to be protected is protected, and whatever's not, that's perfectly fine. And the pleadings could be redacted and so on. But that I had to file a pleading by last week, Friday, in response necessarily undercut the defendant's premise of their motion. So they did not have to file their motion to compel the day after they filed the motion to determine the confidentiality is what I'm getting at. And by forcing that issue and forcing us to respond within the parameters, it necessarily undercut the premise of their sealing. So,
Any
and
response?
I mean, I don't know what Mr. Quinan wants to say, so it's hard for me to say that. I mean, I didn't think it was the least restrictive means. I really don't care so much whether it's
Oh.
sealed. I think the Miami Herald has something more to say about that, so I would leave it up to the court.
The
I just felt it
shade.
needs to be the least restrictive, and if you ask me, that's what it was.
All right, let me hear from,
She's like, it's what's out there in the public media, the public, the Miami Herald, ma'am. I don't care. I just dropped the Discord link. You're not allowed to join if you're not cool. Thank you, Sarah. I appreciate you too. It's game over for her. Okay, we're going to be seeing this trial in 2025. Do you think she's guilty? You think she's a toxic girlfriend? Gentlemen, I'd like to hear from you too.
remind me again your name. I have it here.
Scott.
All right. Mr.
Females
Ponce, if
too,
you'll come
but-
forward to the microphone, please.
Yep.
Thank you.
Good afternoon, Your Honor. Scott Pons from Holland and Knight on behalf
I
of the Miami
could
Herald.
mention some names.
I think maybe the best place for me to start is to explain why I'm here. I mean, obviously, anytime a motion comes across saying sealing criminal proceedings, my client's antenna goes up. But this one in particular, when we got the motion and read the motion, it seemed to me that there were discrete issues that were kind of being conflated and bouncing off each other. And when I emailed counsel for the parties from vacation, no less, but when I emailed counsel for the parties to try to get an understanding, I got maybe even a little bit more confused. Although the judge I clerked for at a law school said, never say you're confused. But as I read it, what seemed to be my understanding of it was that there's a document, the defense contends it's privileged. The defense would like to make that an exhibit to an amended motion to disqualify. And it seemed like the issue of whether the document is privileged was going to be briefed in the disqualification papers also. And that seemed to not be the least restrictive means. And that was our concern, was that a motion to disqualify the state attorney's office needs to be done in public. This is a public institution, and the notion that that briefing might be sealed was problematic, especially problematic because it seemed like it didn't need to be. So our thought was,
Adi
and
needs a
I
chill pill.
apologize if the papers were presumptuous. I don't think that they were, was that it made sense to determine in the first instance whether the document's privileged. Because if it's not, huh?
I'm fine with the way that you outlined it.
All right. Well, thank you. Makes me feel better then. So the thought being that if the document is not
The loca.
privileged,
Me?
then
Oh, you mean
I
Courtney?
don't know that there's any basis to seal any document to which
Pause. I thought you were talking about me. I want to make sure I don't miss anyone. Hello, Unique Prepping. Thank you for having me on your panel last night. It was so fun. Definitely will be back. No clock. Kalosak says, no sabía que un poco de español, ¿verdad? Oh, okay. I see you. Dang it. Who? Daddy needs a chill pill. Hello, Witch. Happy New Year. Against all. I keep thinking the cameraman has a cannon. I think it's a very spicy hearing.
it's attached. If you find the document is privileged, and again, I'm not attorney for the parties and I'm the stranger here and I know least
get
about
married.
this than everyone in this room.
Don't
But
continue.
it's not clear to me why the document would need to be attached to anything. I mean, your honors reviewed it. Your honor will determine it's privileged. Okay, the state saw it. Is there a basis to disqualify him on that basis? I don't. When we talk about least restrictive, I'm not sure why the document would have to be attached to something. But again, I think in the first instance, our concern was that there was suggestion in the papers, at least as I understood it, that the issue of whether the document was privileged was going to be briefed as part of the disqualification issue. And that the state's position was that if that were the case, then everything in the disqualification papers had to be sealed. And that felt like too much. So I'm happy to answer questions if you have any. I obviously can't speak to the privilege issues, nor do I want to. But that's kind of why I'm here. And
This is
why
wild.
that
Took a
came
life
up
away.
on our
How does
radar.
anyone
I
feel
tend
about
to
that?
agree with you.
Right.
As to the way that you've outlined it,
Right,
which is
pardon?
again, why I've asked the state to explain to me why it is that I can't simply rule on this being privileged or unprivileged. And if I do rule that it's privileged, why it means that everything attached to it must also be sealed. And I kind of understand your argument that in order for you to make a full analysis, you believe that you have to reference the exact
Well, if there's,
exact portions of all the bullet points in the email that was sent. But I'll let you address what it is.
well, Judge, I mean, again, if the topic has been voluntarily disclosed and it's been voluntarily disclosed, whether it's,
Aside from
so-
whether or not I say that I do rule that it's privileged.
sure,
Why, again?
okay, so then.
Yeah, but say that I do.
Okay, so then part of the analysis as it pertains to both the deposition and disqualification is what prejudice, if any, right? What prejudice, if any, exists from the inadvertent disclosure of this document, right? And the items contained within that document. Well, what prejudice, if any, exists to the defendant if her lawyer went on TV on July 8th of 2023 and said,
Oh.
we are doing that checklist?
Well, I don't think that that's the analysis that we're talking about for sealing.
No, oh, I'm sorry, I
We're talking
misunderstood.
about sealing right now.
Oh, Judge, again, the parameters is if the court assumes that it's privileged, then I can't discuss those materials openly, right? So if I can't say, you know, they said they were gonna hire blank, and they also said that on TV. You see what I'm saying? If the matter is sealed, I can't say they said this on TV. There is no prejudice.
This is
Yes.
wild.
So here's where sorry to raise my hand, I was in third grade. Where I get confused.
I'm not in third grade.
Why would that be a discussion in the disqualification context?
Because if there's no prejudice, then there's no basis to disqualify.
Oh,
Okay, I mean, it's just something I'm trying to understand, trying to be a partner
Yeah.
here and work through this, trying to
So-
understand why. If there's a determination made that the document's privileged, and there's a determination made that the state saw it, I'm trying to understand why are we still talking about what's in the document or not, and a disqualification issue, if that matters.
Because again, if it's in a privileged document that was assuming it's privileged, because we don't take that.
okay.
position.
Can we make this like real life right now? So the assistant state attorney, I repeat, leaked information via email. Go back and watch that live after this. Do you agree, right? Do you agree that they should seal this document if it was leaked by the assistant state attorney? Or do you think she's guilty because she's a toxic OnlyFans model beating her boyfriend up? I don't know. Or maybe not. This is a shit show. Throw out enough words to confuse everyone. I kind of like it, them arguing in the courtroom.
And the basis of
Mhm.
disqualification is they
I do,
saw
I
our
like it.
strategy. It's like, but you also told everybody your strategy.
Or why
Then-
should you be disqualified?
Yes.
Okay,
And
that's helpful. I'm
that's
just
the
trying to
problem.
understand.
And that's the problem is I cannot. I mean, again, if the court, listen, Google alerts are a beautiful thing. And so everything on this case that has come up from the defense telegraphing their case ad nauseum, it has come up. So again, half of that, from my original viewing of that, and again, I haven't parsed it recently, quite literally everything on there has been discussed in one respect or the other.
Like you could
So,
reference the bullet points without going into exactly what was in that document if I did rule that it was privileged, because obviously the balancing test here is
This is a good judge.
the issues that you guys are talking about regarding the public interest, and there is a right for the public to, you know, view pretty much everything in this criminal case minus what might be
Mhm.
privileged. So
Privileged
do you
information.
not think that there would be a way to craft your response if I did rule that it was privileged in a way that didn't actually quote anything in that? Because I feel like you could. You're
yeah,
very
Judge, I could theoretically say bullet point number 1 and then X, and bullet point number 2,
you could.
then X. But then X was already disclosed, outlines what bullet point number 2 is. So for example, I'm just going to use something that is in the public domain. Find 𝗟𝗏𝗃, right, is the witness that is alleged to have seen everything else, right? Off the top of my head, I don't know if that's there, but you guys check on me. So let's say that's item number 2, find 𝗟𝗏𝗃. So instead of saying, for example, item number 2 was disclosed to the media on this date at this time by Mr. 𝗟𝗏𝗃 when he said, we've located 𝗟𝗏𝗃. how am I not disclosing item number 2 in making that argument?
Isn't it just you're not using his name?
I mean, I think that you could just say the witness was,
I mean, that's the point is how is it that I don't, in saying,
well, listen, I don't think that I don't think that you need to worry about that. I think that you can make the argument if they've already disclosed it and if it's in the
Does
public
that mean you
domain
think she's
already,
guilty,
you
Grace?
can reference whatever's in the public domain.
Semantics, right, Dee?
And that issue is the defense issue.
yes, and that, I mean, that's, we've already articulated
Yeah.
that as much.
So,
But that's what I'm saying is at this juncture, we've already gone as close as we can without going and making a deeper analysis on our motion to strike. So at this point, that's why I'm saying is it the defendant's attempt to maintain the records confidential is,
that's
is-
their issue
yeah.
as to whether or not they have already gone public with
Whoa,
this
whoa.
information, but I do think.
One at a
that
time, Judge,
I
one at a
could-
time.
I could
Judge
give you
Melly.
the parameters and you could easily, I think,
About to
draft
give
a
everyone their
response,
sentence.
knowing that I am able to see the
Hmm.
document that wouldn't necessarily quote the document. You know, your reference of any public disclosures by the defense, I mean, feel free to reference that in whatever way you want to. It doesn't mean that you're the one putting that,
Good
you know,
point. Rich.
quoting the document. I think that's on them.
I also think that if that becomes an issue, we can always go sidebar. Mr. Quinan can lay forward, to the court, off the record. This is what I'd like to say, and I can't say it because of
And
this. And then we can decide that,
that's
yes, okay,
fine.
now there's a basis. We should seal it because you can't make that argument unless it's out.
And to agree with you, and I understand what you're saying now. I understand what you're saying about needing to show prejudice for all the elements that are in there, but I think that could be done without referencing the document. Okay. All right, now I lost my place. All right, Mr. Ponce, was there anything else that you wanted to say about that?
Unless you have questions.
All right, do you have anything that you want to say about your response to what Mr. Ponce had said? Because it seemed like you were essentially in agreement with the idea of going with the privilege first and then deciding what needed to be, whether anything needed to be sealed. But you said that there was one thing that you disagreed with, I feel like. No?
No, I don't think so. I
Okay.
think, it was only that if the court doesn't find it's privileged or finds that the defense waived it, I think that Mr. Ponce's argument is then, okay, then it should be disclosed. And our argument would be no, because it still is our mental impressions of the trial and there's no reason for the public to see it. And unlike what Mr. Quinan is saying, that yes, the timing now is such that it's been disclosed. Some of these things have been disclosed. They're part of the public record, as you said. And we have discussed it in the media, but not all those things have. And that
Ooh.
entire document is a privileged document, whether we have
There's
disclosed some
information
of
we
it
don't know.
or all, it doesn't mean the whole thing should be disclosed. It's privileged. And so, and I can
Is it
matter of
Miss
factly
Lacey?
say that not all of those items have been discussed in the media at all. So,
And I don't think that he's disagreeing with that.
Grace is like
I'm
telling everyone.
neither agreeing nor
you want to
disagreeing, Judge. I
stay.
can't, I
Right.
can't.
You-
Again, I've on purpose recently avoided.
Okay, so yes, you've got your bullet points. All right, did you want to address anything else that Mr. Ponce had said or that the Miami Herald's concern is other than what you've already said about why you believe that there needs to be a broader?
No, Judge, we were generally in agreement to maintaining that prophylactically. Our position was just that, let's get this over with. And then after the fact, let's just get everything over with. And then after the fact.
Yeah,
The idea was to get it over
Thank you,
with.
Sarah,
before
for
the new
being
year, but
here.
It's not gonna happen,
11
or at
appreciate
least at
you.
this point. Okay, so I agree with the idea of ruling on the privilege first. And then deciding what needs to be. Actually, I mean, I can make the ruling, I can make both at the same time, based on what you guys have said, unless you have any other arguments that need to be made.
She's like, my
Judge,
decision
as it
is already
pertains to
made.
the waiver issue, I mean, I didn't go down the
No, there's no
the
date for the
dynamics
trial
of
to be
um
announced.
that again, we have separate parties. And by separate parties, I mean, there's a state of Florida
They
versus
don't
Courtney
bite
Clenney.
me.
There are
They don't bite
witnesses
me
within
in.
that
Or
case.
maybe just a
Those
little bit.
witnesses can have representation at the time Kim,
Sorry, and by both, I'm sorry, I didn't mean to cut you off. By both, I mean, I'm perfectly fine with ruling on the issue of privilege and what should be sealed, not that we're arguing the motion for.
no, it's on the privilege aspect, because again, there
Oh.
were certain aspects of it that go more towards that dynamic. But essentially the broad stroke rule that the defense is trying to propose, where the parents are always agents of the defendant or have been always agents, is not one that's actually premised within the doctrines of attorney-client privilege or within the jurisprudence or within that rule. And specifically what I'd refer to is several different dynamics. First is the defendant has several jail calls with her parent. Does that mean that because her father administers her money, that I can't review the jail calls that she has with her parents? Logically, no, that doesn't follow. Notwithstanding that they're being told it's
Very
recorded
interesting.
or not. That's completely immaterial, whether it's
attention.
privileged or not.
You're going
You
to be
know, we
quizzed.
should not be, even if it is recorded, I believe all jail calls are recorded even with counsel, but we don't get the ones with counsel. We explicitly are excised. They have to fill out paperwork and so on and so forth. So whether it's recorded or not is completely immaterial. And what's happening here is, for lack of a better term, because they keep using this term Team Courtney in this group chat, that was not evident in the group chat, first of all. But notwithstanding that, is just because you have a support group and everybody wants to know about what's going on and what's being done, it's incumbent on the counsels and their client to keep those lines of demarcation. For example, if Ms. Puglisi met with Ms. Clenney at the jail and said, we're going to do X, and then she picks up the phone and calls her mom and says, my lawyers are doing X, that privilege is waived. Ms. Hogan, I actually prosecuted another case where there was a similar circumstance where a person their representation was paid by a third party. I'm not going to go into the details because it's a little bit sensitive, but that third party had a complete barrier to the representation.
Please do.
Certainly, if
Please
you got
go
a
into
call and
details.
say, look, we need X more money because we have to hire an expert, I got to talk to my client about we should excise from there. And I explicitly use the example of when parents go in with a client to an interview and how the parents are supposed to be excluded from that interview with the client if they are to maintain any privilege, because if it gets discovered, we can't compel that testimony. Which, again, to the further privilege aspect, is the defense in December of 2022, when this email is being sent, knew A, the defendant was in communication with her mom, both written and oral.
Oh,
That they provided us photographs that Deborah Clenney took from her device on April 6th, 3 days after the homicide, purportedly showing bruising that was, again, purportedly caused by the victim. And so they knew that we had a basis to want Miss Deborah Clenney's phone and the contents of that. And we could have subpoenaed that, assuming she was within the jurisdiction for me to subpoena it. So what is on her phone? That is a textbook voluntary disclosure to third parties.
what is on her mom's phone?
And again, calling it privilege, naming it privilege does not make it so. That document could have been called privilege, and it could have had the scores for the Heat game and the stats.
If you don't remember, she called her mom before she called the ambulance when Christian was bleeding out. Yeah. BC Girl, hi, love. I wanted to say hi. I wanted to make sure I didn't miss anyone. 𝗟𝗶𝗸𝗲? Am I saying that right? Don't come for me if I'm not. I apologize. My apologies. So who leaked what? So the state assistant prosecutor leaked emails. If you didn't watch the last live, go back and watch it. We covered the document. The assistant state attorney leaked emails. He was sending emails to one of the cops or investigators on the other side. So I don't know. They might win this one as well. The parents' charges got dropped. This might actually happen.
That doesn't make it so. And in
It's
this
going to be a
context,
trial for
even if it
2025.
was,
Take notes.
which
You're gonna be
we don't
quizzed
necessarily
at the
disagree
end.
that it was when it was created.
We're doing a quiz. Just kidding.
We disagree that it was
move.
opinion, because it's just facts of what we're doing.
Hello, Emery.
But once it was put into an email and sent to the third parties, that was waived. And just as a perspective, the two exceptions there are for the purposes of the representation, and I forget the second one, you had it, It's for the purpose of the communication functioning, I believe. It's the second one that you mentioned.
Reasonably necessary for the transmission of the
And that's what
communication.
people-
Correct. So it's reasonably necessary. So that would be Outlook or Google or whoever the servicer
free
of that email
speech.
is. We didn't intrude on Google, et cetera, or any of that stuff. We got it from Miss Deborah Clenney's iCloud. A, not knowing that there was a representation there, and then B, under the circumstances where that email was even open, it said update, not update privilege or privileged communication or any of that aspect. And B, the document did not reference Kim and Deborah Clenney's representation in any way. It was explicitly about Courtney and what they were doing about Courtney's case, which again is textbook, top to bottom, within four corners, voluntary disclosure under 90.507.
Judge, I'm just going to say that I think the state tends to join the two privileges together, and we have to make sure we keep them separate. Attorney-client and opinion work product.
Lots of case law going on here.
Opinion,
Yep.
it doesn't have to be your opinions. It says mental impressions. Mental impressions are your thoughts. There's no question. These were my thoughts.
Oh.
And yes,
Isn't that-
it could have been the scores to the Heat game, but it was not. And it said privileged on it. And the prosecutor should have stopped
No copying,
when he
nothing.
saw a communication from attorneys to anybody and should have said, oh, I see an attachment that says privilege. He didn't stop at that point. He actually forwarded it to law enforcement, thereby making it a public record. So we have to, all his
Mhm.
descriptions
record,
about, it's
ma'am.
not a jail call, which of
Need it.
course is recorded. And it doesn't have
Need
to
it.
be
Right.
about finances. It doesn't have to say the magic words. This is, we need money from you. It says disclosures and furtherance of the rendition of legal services. These are points that help to justify what is being done in the case to represent their child. So I think it's very clear this is both attorney-client and work product, and that there was no waiver at any time, especially in the work product. It was meant to be kept from the eyes of our adversary.
Oh,
And you don't believe that that was waived when you disclosed it to the parents?
oh,
In
as a third
opinion,
party?
no, because opinion, especially opinion work product, it
Here we
talks
go.
about you can disclose to third parties. The question is whether you reasonably could have known that it would get to the eyes of your adversary. So by
Oh.
giving, they're two totally different standards. So by us giving this information to the parents of what our opinion is in the case, the question is, could we have known that the prosecutors would have seen this email? And in order to prevent that, that's why you write privilege, so that you know that only the family, the people you're sending it to, are going to see it.
ma'am.
I have a slight disagreement because Ms. Puglisi keeps referencing adversary. So first, again, as witnesses, whether by
Eyes
us or
of your
by the
advocate.
defense, they would be
Mhm.
subject to
That's
subpoena.
right, Dee Dee.
And we could have taken sworn statements of them and possibly had
She
discussed
was
that where
always
we asked the
nasty to him,
question,
right?
have you discussed your daughter's
I agree,
case
Lucy
with
girl.
the lawyers? So it wouldn't be a question about, did you discuss it as a witness and client of theirs? It would be, did you discuss it regarding her representation? And they might have been compelled to answer that.
It's a
The
different
second part
pattern
is
of
that the
behavior.
standard is not adversary. It's that the communication was made with the intent to keep it secret. Now, certainly it was meant to keep secret with Kim and Deborah Clenney. The problem is that as third parties to state of Florida versus Courtney Clenney, it's a voluntary disclosure. The very act of attaching it to the email and sending it to them constituted the waiver.
Judge, and I don't totally understand what he's saying with respect to, there's no way they could have been compelled to
You don't
answer that. But
understand the man.
adversary
Mm.
is the state attorney's office in this case. That's who the adversary is to Courtney Clenney. And so clearly it was not meant to do that. And I can find the case, but it does talk about that.
I'll look at it.
Okay,
Yeah, my understanding is adversarial party.
okay.
Okay. All right, anything further before we stop for the
Mhm.
day and I give me time to read through everything and issue another written order?
No, Your Honor.
No?
So my order will be number one, on the nature of privilege, whether I believe that it is privileged or not privileged, and two, if I believe that either it's privileged or not privileged,
to know.
whether I believe that anything should be
We need
kept
to know, Judge.
confidential, and if I do believe that it's confidential, what should be kept confidential? Okay, so it's going to be three parts. Everybody follow that?
Yes.
All right, and you're not Marvin, so I don't know how long to ask you for the transcript. What is your name? Alex. Okay, Alex, if I
You're not Marvin.
want a transcript, will I be able to get it in 10 days?
Where's Marvin?
Given the holidays, 10?
Yeah.
They should be.
Give
there.
her bond, no.
Copies.
They want a
No, I have
bond or
copies
they want
of
her
the
out
orders
on
there.
house arrest
If
while she
you
goes to
look,
trial.
There should, you guys, Ollie. No. All right, so let me reset it for 10 days for
Her cover.
transcript, and then hopefully we'll get the transcript then, and then I'll give it a.
I understand that.
And if I get the
Hello,
transcript, I'll give you
Miguel.
all a copy of the
Good to
transcript.
see you.
Okay.
Thank you.
Judge, are we not then going to the motion to depose today? You're going to wait
not.
until that? Okay,
Because I agree, they should
Love
be
you too,
separate.
Sarah.
okay.
Could have been a drug psychosis. I think she's violent
1-3 is 10
in
days from now.
nature. Maybe mental health issues, trauma.
That makes me feel bad, but we'll do 1-3 and yes. We're just gonna keep moving. Okay. All right, thank you. And then what was your name again? Alex? What was your last name? What is it?
Oh,
But what's your last name?
So, SI? No.
Did you want to set a date for,
Right now, I'm just gonna give the transcript and then, I mean, you can try to set a date, but let's just, everything takes longer than I think it's gonna take, so.
so once we get the ruling,
she
we
was like
should
a
call
violent
your
individual.
JA and ask
I
for,
think once we
Really?
get the date for the ruling, you can probably come up with the date for that.
I don't think
Okay.
she's smoking
that
bath
motion
or anything. I
deposition.
just think
Alejandro
she's
Silva, and are you also a
toxic
Dawes?
drunk who has a lot of issues.
Okay, all right, thank you.
Does it make it
All
okay?
right,
No.
happy holidays, everybody.
thank you, you as well, Judge.
Yes,
Look at her in
so
the
we're all
corner.
gonna take a brief break and then we're gonna go on to White. I'm sorry, but I am giving you guys lots of days off. so.
Oh,
What's today, the 19th? 18th. Today, the 18th.
happy New Year's, Miguel. Thank you for being here. She was very callous after she killed him. She went in with a lie. Like the man she killed never existed. Right,
What's that?
X? Hello, X. Good to see you.
Nope,
Good
we're
to
going
see you.
to give, I'll give you guys a, well, who do we have here for Rashad White? Do we have everybody here? All right, I'll give you guys a 30-minute break, and then we're coming back.
It's pretty much over. So there we go. Hearing for Courtney Clenney. We will see a trial in 2025. Do you think she killed Christian intentionally? Was she drunk? Is she entitled? I think she was always violent when she didn't get her way. Substance was only a tool she used to excuse her narcissistic violent behavior. Okay, but why does one become violent, right? Is it like a mental health issue? Like she's always been violent? Like there's trauma? Is there abuse in her life where she feels like she has to abuse people? Does that play a role? What do you think? Do you think she should? I mean, we're going to see the court. We're going to watch it. Right. Don't cover me intentionally. If you haven't watched the lives I did, go back and watch. I do a deep dive and then we do body cam footage and the crime scene. So you believe she learned, 𝗟𝗶𝗸𝗲 says, you believe she learned at an early age to be violent to get her way? No, but I don't know. I guess we can get into a deeper conversation of, do you think people are born violent? Right? We have had this conversation here before. Or does their environment make them that way? Or experiences? I do think she has antisocial personality. I do definitely think she was drinking way too much, and she's an OnlyFans model, so I'm sure that comes with a lifestyle, right? Or just got stab happy, right? Maybe she was just angry and she's using the domestic violence excuse. After this hearing, they have not announced a trial date. Like I said, it's to be determined. I have notes. Let me pull up my notes for you. So January 27th, retrial, February 10th, Lawson trial, February 24th, Vallow, May 5th, Combs, Kohberger, Clenney, and 𝐻𝐿𝐿 and Melly are all pending. So we have yet Oh, thank you, Miguel. That's very nice of you to say. Yes, I would give you my sweater, or I would just say, like, just come here, we can cuddle. Just kidding. Pause. Calm down. She probably plays with her nose too. Oh, okay. I get what you're saying there. It also wasn't the first time she stabbed Christian. And we know that there's a previous incident where she threatened her ex-boyfriend before Christian to unalive herself in a traffic incident. So it's not new. Her violent behavior is not new. She did it with her ex-boyfriend and she did it with Christian as well. 𝗂𝐵𝗸𝗲 trial. I've been covering some of it. Yeah, I think I will cover 𝗂𝐵𝗸𝗲 for sure. And I will cover Clenney. No Diddy, no Diddy, no. I had to take a pause from Diddy. I know we've been covering the documents. I can't keep up. I'm like, it's too much. But we're going to do some deep dives. We're not going to cover the most recent documents, but we're going to deep dive back into the Diddy stuff. Aw, I appreciate you guys for being here. It's supposed to be 3 months long. Yeah, I'm excited for this trial. I really am. Anyways, I appreciate you guys for being here. I don't know. I wanted to do jail calls tonight. I don't know, because I think it's past your guys' bedtime. No? Yeah? Some people are predisposed to have violent tendencies. Not everyone acts on it, though. I strongly doubt she was acting violent. I heard that she was being theatrical or effect. Okay, so you think she was just violent with her boyfriends, like intimate relationships? I'm curious. 8:20 here, which is like, it's not past my bedtime. It's early here too, but introducing, yes, we have new case. Well, we're gonna follow part 2 on the Jared case, and I do have new cases coming up. I do. 11:21. 𝗂𝐵𝗸𝗲. What's a bedtime? Oh, okay. So you guys are saying you have no bedtime. Okay, but you say that, but then you're sleeping when I come on here and do jail calls. I don't blame you. Get your beauty sleep, baby. I think she thought no one would. I think that too. I don't think she probably thought it was just another fight, another drunken fight. Was it intentional? Yes. But I do think that maybe she could have thought that it was just another night of them fighting. Plain that you won't put hands on me, crazy chick angle. Okay. I'm an explosive. Oh, okay. I watch from the clouds, but I'd be watching. Watching from the clouds. Augie, get to bed. Damn, missed it again. Michelle, I need you, Michelle. Where have you been? It's okay. Don't worry. We're going to be covering true crime all weekend. Accountable. I agree. I have more jail calls, two new cases, and then we're going to follow up on some that I've done before. And then I think I want to cover Wade Wilson. I know there's just an interview that I want to cover. I haven't covered him in a while. It's 11:30 p.m. in Montreal. BC girl, is that where you're at? Okay, that's cool. Yeah, good question. If they could care more about surrounding the man that she killed. Yeah, RIP Christian Obumseli. But I appreciate you guys for being here. Like I said, we'll be back for more true crime tomorrow. Make sure you watch the live from last night, Dr. Hoover. Make sure you go back and watch Courtney Clenney lives. I'm going to put descriptions in. I know, Gracie, don't come for me. And I always drop all the references, all the videos, all the sources, all the information. So I will get that updated, get the playlist updated. It's Friday, so you already know what that means. We're probably going to be making some verticals, members only, X-rated. Well, you know what I mean by X-rated, like language, topics, all of the above, not the other type of X-rated. Just kidding. Anyways, I'll be rewatch crew today. Okay, rewatch. Thank you, Michelle. Yay! Thank you for being here. Make sure you guys all hit the like button. I love you so much. Thank you for everyone who gifted. Welcome all new members. I'm locking up the detention. Noted. Yeah, lock up the detention. I appreciate you guys all for being here, and I will see you on the next one. Bye.